afternoon, everyone. I welcome you all to Aviation Dispute Panel. On panel today, we have Daniel Almansur, Mr. Nitin Sarin, Dr. Akhil Prasad, Lupin Jahang, and Dr. Brendan. Inviting our first speaker, Daniel Alman, who is currently Special Counsel at Norton Rose Fulbright. Speaking about source education, he has pursued BA LLB Honours from University of Melbourne and LLM from Columbia Law School, where he has been felicitated with several prestigious awards, including James Kent Scholarship. Highlighting So's profound knowledge of the subject matter, he has published his work on international arbitration at International Law Office and many others. With that, we invite you, sir, to grace the session. Thank you so much.
Well, thank you to the volunteer for that generous introduction. And I would like to thank MLNU Mumbai and the Centre for Arbitration and Research, as well as the Centre for Training and Research in Commercial Regulations for the opportunity to present at today's conference. I'd like to start by acknowledging that I'm delivering these remarks from the lands of the Gadigal people of the Eora Nation, who are the traditional custodians of the land here where I am in Australia. And I would like to pay respect to elders, both past and present, and extend that respect to any other Aboriginal and Torres Strait Islander peoples who may be joining today. I'd also like to acknowledge the eminent speakers who have come before me, Professor Dr. Anil Variath, Dr. Vinod Kumar, Dr. M. Subramaniam, and the Honourable Justice Ravindra Bhatt. I thank them, each of them, for their insightful comments. I'm really delighted to have been invited to speak at this Global Aviation and Space Disputes Conference because I think these topics that are being covered here today are such important ones for us all to be thinking about. And so I commend the organisers for putting on this fantastic program, and I commend everyone in the audience for joining as well, whether you're joining just to learn or whether you're an active participant in this area who's keen to be part of the discussion. I'm in the somewhat fortunate position of being the first speaker on the Aviation Disputes panel, which means that I'm not constrained by anything my fellow panelists have to say, and I'm able to cast quite a broad net. On the other hand, it also means, of course, that my esteemed colleagues on the panel will have the opportunity to respond and, wherever necessary, to challenge what I'm going to say. And so I will bear that in mind as I try to provide an overview presentation of the aviation sector disputes topic. I'm going to cover three areas in my remarks today. First, I want to step back and offer an overview of what we mean when we talk about aviation sector disputes. It is useful, I think, to break down that general category into some smaller conceptual buckets and to provide some examples. Second, I want to address this specific role of arbitration in aviation sector disputes, both in terms of whether arbitration is a useful mechanism for those disputes, and also whether it's necessary to have specialised arbitration rules and institutions that are dedicated to the sector. And third, I want to focus on a particularly recent development in the form of the Hague Court of Arbitration for Aviation. So first, what is on the table when we speak of aviation sector disputes? The first thing to say is that we are talking about a very large sector. Before COVID-19, approximately 100,000 commercial flights took off each day globally. The global aviation industry was supporting more than 85 million jobs worldwide, and it accounted for about 4% of global GDP, which meant that if it were a country, it would have ranked 17th in size of GDP, comparable to Indonesia or the Netherlands. Aviation enables trade and tourism and emergency response on a scale that would have been unthinkable just a century ago. And despite the shock of COVID-19, the International Air Transport Association estimates that global passenger travel will return to its 2019 levels by 2024, and then it will expand substantially over the next 2 decades. By 2040, it's estimated that the number of global air passengers will rise to 7.8 billion air passenger journeys per year, almost double what they were in 2019. And our region is expected to be the fastest growing region. The Asia Pacific is expected to add around 2.5 billion additional passenger journeys per year in 2040. Despite those growth forecasts, it's important to acknowledge the challenges faced by the aviation sector today. And I would like to point out 4 in particular. The first is the ongoing impact of the pandemic. The number of seats offered by airlines last year dropped by about 1/4 compared to 2019, which responded, of course, to an overnight fall in demand 2 years earlier for air travel and to financial losses for the airlines. Related to the pandemic, anyone who has travelled in recent months will be able to confirm that the aviation sector has been plagued by staff shortages. As travel restrictions have been lifted and demand for travel returns, it has been a challenge for airlines and airports to ramp back up with enough skilled workers. Supply chain problems too have plagued the air industry. Suppliers and manufacturers of aircraft parts have confronted shortages in everything from raw materials to small electronic components. And finally, we've seen a surge in fuel prices. The sanctions on Russian oil and gas imposed in the wake of Russia's invasion of Ukraine have driven up the cost of jet fuel by more than 50% by December last year. And that's been happening alongside a push for decarbonisation as countries and industries work towards the net zero goal by 2050 under the Paris Climate Agreement. What all of that means is that in aviation, we have a very large and critically important sector which has faced incredible challenges over the last 3 years and is facing some new challenges as it emerges from the COVID era. With that context, what are the sort of legal disputes that arise under that general umbrella, which we're calling aviation sector disputes? I think it's useful to distinguish between 3 different types of legal disputes. One is disputes between private parties. The second is disputes between a private party and a state. And the third is state-to-state disputes. In other words, disputes between countries. And I want to talk through these 3 subgroups in reverse order, starting with state-to-state disputes. When it comes to aviation, the rights and obligations of states as a matter of international law are generally governed by a handful of treaties. In terms of multilateral treaties, there are 2 primary instruments. The first is the 1944 Convention on International Civil Aviation, which is commonly known as the Chicago Convention. The Chicago Convention has 192 contracting states, and it's been called the Magna Carta of dispute resolution for international aviation. It is the treaty that established the International Civil Aviation Organization, or ICAO, which is a specialized agency of the United Nations for coordinating and regulating international civil air travel. Essentially, it's the body responsible for setting standards for global aviation. And it's the reason we have generally a very harmonized global sector in terms of crew licensing and aircraft manufacturing and environmental regulations. Chapter 18 of the Chicago Convention addresses disputes and default, and it enables contracting states to bring proceedings before the Council of the ICAO, whose decisions can then be appealed to the International Court of Justice in The Hague, which is commonly referred to as the ICJ. This mechanism has only been used a handful of times in the nearly 80 years of the Chicago Convention. Until last year, there had been 5 disputes brought before the ICAO. And then in March last year, Australia and the Netherlands also launched legal proceedings at the ICAO against Russia over the downing of flight MH17 over Ukraine in 2014. The second instrument to be aware of is the 1971 Convention for the Suppression of Unlawful Acts against the Safety of Civil Aviation, commonly known as the Montreal Convention. As its name suggests, the Montreal Convention imposes an obligation on states to provide for the safety of civilian flights and to refrain from using weapons against civilian aircraft. And Article 14 of the Convention also allows states to refer a dispute to the ICJ if their negotiations fail. And a recent example of a dispute under the Montreal Convention is that in December last year, Canada, the United Kingdom, Sweden, and Ukraine have requested binding arbitration with Iran over the downing of Ukraine International Airlines flight PS 752 shortly after its takeoff from Tehran in January of 2020. Now, if there's no agreement within 6 months about the terms of organising an arbitral tribunal, then that dispute may be referred to the ICJ. So those are the two primary multilateral treaties. And then for issues around routes and rates, states have entered into a series of bilateral air transport agreements, commonly known as BATAs. Historically, those agreements provided for disputes to be referred either to arbitration or to the ICAO Council, although in recent years, BATAs have more often referred disputes to binding arbitration only. The other area that is relevant is international trade law, and in particular, disputes before the World Trade Organization. Many people in this audience would be aware that the dispute over aircraft subsidies, which is a dispute between the United States and the European Union, commenced in 2004, is still ongoing today, which makes it the longest trade dispute in the history of the WTO. Those are some of the instruments that govern state-to-state disputes in the aviation sector, and you'll be hearing more about the topic of interstate disputes later in this panel when Dr. Luping Zhang from China University of Political Science and Law addresses you on her speech. The second bucket of aviation disputes which I described was a dispute between a private party and a state. And in our field of international arbitration, we usually think about this as being an investor-state dispute, which is to say a dispute between a foreign investor from one country and some other state where it had an investment. Of the three types of disputes I described, this is the least common, and so I don't want to spend too long on this one, but to give a recent example in the aviation sector, in 2020, Qatar Airways launched investment treaty claims against 4 countries, the United Arab Emirates, Bahrain, Saudi Arabia, and Egypt, seeking damages allegedly arising from a blockade in the Gulf region imposed in June of 2017. Now, the most common type of dispute in the aviation sector is, of course, disputes between private parties, and this will very much be the focus of the remainder of my presentation. And I want to distinguish between 2 categories of disputes in this regard. The first is disputes between a passenger and an airline over issues like flight cancellations or lost luggage. Those are really consumer disputes, and although they are sometimes referred to arbitration in the standard ticket terms of an airline, there are particular issues at play in those matters which I won't be addressing today. The other category of disputes is business-to-business disputes, and these cover a wide range of issues. Disputes under purchase agreements for aircraft or engines or parts, disputes under supply agreements around fuel supply, for example, aircraft leasing contracts, finance disputes, and then, of course, technical and maintenance disputes, which might arise under a maintenance agreement. And all of those are really contract disputes, and they come up every day of every week all around the world. And so that brings me to the end of my first section of these remarks. And I want to move now to addressing the particular role of arbitration in aviation sector disputes. And I want to focus on those business-to-business disputes. One of my co-panelists, Mr. Akhil Prasad from Boeing India, will also be addressing the use of commercial arbitration in aviation disputes. And so I will limit this part of my remarks to considering two questions. First, why might arbitration be a useful mechanism for resolving business-to-business disputes in the aviation sector? And second, is it necessary to have specialised arbitration institutions for aviation disputes? On the first question, the starting point is that aviation is an inherently international industry. Airlines carry passengers and cargo from one country to another, and a smooth flight also depends on commercial cooperation between service providers across the globe. And yet aviation is one of the few global industries in which cross-border commercial disputes are generally resolved by litigation rather than arbitration. Now, it may be that many arbitration sector participants are comfortable with the courts and unfamiliar with arbitration processes, and it may well be the case that litigation is more appropriate than arbitration for many regulatory and personal injury claims. But I want to make the case today that international commercial arbitration may often be better suited for other common aviation disputes. Arbitral procedures can be tailored by the parties, which can result in faster and less expensive proceedings than you will get in court, as well as a procedure that better reflects the particular aspects of a dispute. International arbitration before a tribunal of 3 arbitrators, for example, can also avoid concerns about a home field advantage by one side, because it removes a dispute from the local courts of any one country. Most importantly for the aviation sector, arbitration is binding in the sense that there is no appeal procedure like there is in court, and its outcomes are enforceable. The widespread adoption of the New York Convention, which has been signed by more than 170 countries, means that foreign arbitral awards can be enforced in domestic courts more easily than most foreign court judgments. And if we think about parallel industries, these are the features that have led maritime shipping to rely heavily on international commercial arbitration. The LMAA, which is the London Maritime Arbitrators Association, handled more than 16,000 disputes in 2019 alone. And then you have the SMA, the Society of Maritime Arbitrators in New York, the SCMA, the Singapore Chamber of Maritime Arbitration, and the Chambre Arbitrale Maritime de Paris, which add many more cases to that tally. Indeed, the most widely used standard form documents in shipping, like the New York Produce Exchange Form, provide for arbitration using rules developed specifically for that shipping industry. Those examples from the field of maritime arbitration lead to my second question in this part of my remarks. The world's leading arbitration centres, such as the International Court of Arbitration of the International Chamber of Commerce or the Singapore International Arbitration Centre, those are generalist institutions. So even if we accept that international commercial arbitration offers benefits for aviation disputes, what are the added benefits of specialised arbitration rules and institutions specifically dedicated to the aviation sector? I think there are 2 added benefits to consider. The first is that specialist arbitral institutions work well in highly technical industries because they give the parties access to decision makers with specialised knowledge. Arbitrator members of the LMAA, for instance, must have at least 15 years' experience in the maritime industry. Professional knowledge and expertise is equally relevant in aviation disputes, which can simultaneously involve commercial, economic, and scientific issues, as well as industry practice. The next panelist you're going to hear from will be Nitin Sarin from Sarin & Co., who will address specific types of disputes that arise in the sector around aircraft leasing and finance. And that's an example of the particular and technical nature of many of the disputes that arise in this sector. The second added benefit is that specialist institutions can develop rules and procedures tailored to the industry. For example, the SCMA has developed a special fast-track procedure for marine fuel claims, which reflects the commercial need in the shipping industry to keep ships at sea and discharge debts quickly. A similar rationale underpins the default position under the arbitration rules of AMTAC, which is the Australian Maritime and Transport Arbitration Committee, to the effect that arbitrations are conducted on paper only, which is to say, without a hearing. And so, as a sector that involves really important technical issues that give rise to a whole series of technical disputes, aviation may be a natural fit for specialised arbitration. And we've seen moves in that direction in recent years. In 2014, the Shanghai International Aviation Court of Arbitration, sometimes called SIACA, was established as a joint venture of a joint initiative, I should say, of the International Aviation Transport Association, the China Air Transport Association, and SIAC, which is the Shanghai International Arbitration Centre. And then in 2016, the AAA ICDR, which is the International Centre for Dispute Resolution, a division of the American Arbitration Association, it launched a dedicated panel for aerospace, aviation, and national security claims. That panel brings together arbitrators and mediators who are leading industry experts who can be called on to handle complex disputes, whether they're domestic, by which I mean American, or international. And most recently, in 2022, the Hague Court of Arbitration for Aviation was launched. The Hague CAA is a private non-government institution which is supported by the Netherlands Arbitration Institute, and it's located in The Hague, which has the benefit of Dutch courts, which are known for being supportive of arbitration, and a city which is synonymous with that field. The CAA's goal is to provide specialised arbitration and mediation services for the global aviation sector. And it offers its own set of rules, which can be called on in an underlying commercial contract or in a standalone arbitration agreement, which would be executed on an ad hoc basis at the time a dispute arises. In the final part of my presentation today, I'd like to focus on the CAA and in particular on some of the notable features of its arbitration rules. The CAA rules contain a model arbitration clause. Now, that clause does not include anything specific about the qualifications of arbitrators, but it does give parties the option of specifying the particular qualifications. This might include industry knowledge or expertise, and it's hoped that parties would be able to call on the CAA to identify arbitrators or mediators with the required experience. When these types of requirements are used well, they can ensure that disputes are heard and decided by tribunals with a sufficient grasp of the subject matter. It's important, though, not to be so specific in the qualities one would be looking for in an arbitrator that it's difficult then to find arbitrators with availability who meet the criteria. The CAA rules address the use of electronic communications by stating that the default position is for communications and submissions to be provided electronically. This is in keeping with the global nature of aviation and the shift towards electronic communication. Although email is often used for communications in international commercial arbitration, not all of the arbitration rules specifically provide that electronic communications are the default mode. And the fact that the CAA rules provide clarity on this point should help to avoid dry procedural disputes. The CAA rules provide for the appointment of an emergency arbitrator who can determine urgent applications for interim or conservatory measures before the constitution of the arbitral tribunal. This empowers that arbitrator to make interim and emergency measures which can offer protection to a party in arbitration by preserving the status quo until the underlying dispute is determined. So, for example, in an aircraft leasing dispute, a claimant might seek an order preventing the lessor from seizing the planes until the merits of the dispute are determined. In a dispute over airport services, an interim order could require runway access to be provided during the pendency of the arbitration. The way that process will work is that within 2 days of a request, an emergency arbitrator is appointed by the CAA, and that person then has 15 days to make their decision. And by way of comparison, those time periods reflect the ICC arbitration rules. So that's the emergency procedure. And then there's the expedited procedure, and it's important as well. The CAA rules provide for expedited proceedings in the case of low value disputes, where the amount in dispute is less than 10 million euros, which is approximately 11 million US dollars. And that expedited process is also available where the parties consent, regardless of the amount in dispute. The tribunal in an expedited proceeding must issue its award within 5 months of the initial procedural conference, giving the parties certainty that the dispute will be dealt with quickly and relatively inexpensively. In a further effort to reduce time and costs, the arbitration can be determined on paper only, which is a common feature in maritime arbitration. And importantly, expedited proceedings can be converted to standard arbitration under the rules, using the full suite of procedural steps where the arbitral tribunal assesses that the standard procedures would be better suited to the dispute. Like most modern arbitration rules, the CAA rules also have provisions for joinder, intervention, and consolidation, which are critically important for managing multi-party or multi-contract disputes. And finally, on the question of costs, the CAA rules have a costs schedule, which sets out clear guidance on tribunal fees and administrative fees. It sets tribunal fees according to the value and complexity of a claim, and then on the basis of hours spent by the arbitrator. To conclude my remarks, it really remains to be seen whether parties in the aviation sector will join other international sectors, including maritime shipping, in embracing international commercial arbitration as a preferred means of resolving business-to-business disputes. And it also remains to be seen how effective the Hague CAA will be in meeting parties' expectations and providing the resolution of disputes in a timely and effective way. There's also scope for the CAA to expand its coverage, for example, by attracting disputes that go beyond what I've described as the classic aviation sector disputes, to include business conflicts arising from the use of drone technology and perhaps also space-related disputes. In any event, in my view, the establishment of the Hague CAA is a welcome step forward because it gives parties in the aviation sector another option for resolving business-to-business disputes. And at least on paper, the rules include procedural measures that are well suited to the sector. That concludes my remarks, and so I would hand back to the organisers and also be willing to take any questions. Thank you very much. I can see that there's one question from Lakshay Benawal in the Q&A, which is that considering HCAA is a private institution, will it affect the willingness of parties referring disputes to it? To just respond to that question directly, I think it's important that it's a private institution and that it's not affiliated with a particular government. In fact, the main arbitration institutions, although they may be supported in a general sense by the governments where they're primarily located, they are private institutions. And so I think the fact that it is a private institution will affect the willingness of parties in the sense that it will make parties more likely to submit disputes rather than an institution that was specifically and formally an institution set up by a particular government, a particular state. Thank you for the question.
Thank you, Mr. Daniel Allman. We are thrilled to have heard you today. The next speaker with us today is Mr. Nitin Sareen. Mr. Sareen is a qualified lawyer in both India and England and Wales, and he's also the managing partner of Sareen & Co. He specializes in asset and aircraft finance, leasing, and repossession. He completed his BA LLB from the Army Institute of Law, Mohali, and his advanced LLM in Air and Space Law from Leiden University, Leiden in the Netherlands. We're grateful to have you here with us, sir. The platform is yours.
Thank you very much, and thank you very much, Daniel, for your opening remarks. It was so well researched and so well presented. I think we can all just log off and go home. But in all seriousness, I thoroughly enjoyed your content, and I really thoroughly enjoyed how you touched upon all the aspects that are really important for the topic we're talking about. Good afternoon, everyone. As the kind gentleman just introduced myself, my name is Nitin Sareen, and I'm the managing partner of Sareen & Co. We're a small law firm specializing in aircraft finance and leasing in India. And we are a small and vibrant bunch of aviation enthusiasts who also happen to be lawyers. So we enjoy what we do. Opening this graveyard shift, as I call it non-graveyard because we really did start after lunch, so we can't really complain. It's a pleasure to be here, and I promise to stick to time. In fact, I plan to be slightly early in my conclusion. Starting off, I would like to say a big thank you to the 93 participants and students of law. This whole idea and purpose of this is for your education, for your experience, so that you can get a holistic view and decide what you would like to do with your careers. Dr. Subramaniam, it's a pleasure to be on the same stage as you. Professor Dr. Anil, thank you very much. Dr. Kiran, thank you very much for having me. And of course, Mr. Chirag, thank you, and my dear fellow panelists. I'm here to speak to you and give you a practitioner's view on aviation disputes with special reference to aircraft financing and leasing. Now, let me just give you a very, very brief overview of what aircraft financing and leasing is. So when we talk about aircraft leasing, it is purely that you're taking an aircraft for a specified period of time for use from an owner, and in return, you are paying consideration for use of that asset. One of the cardinal principles of leasing, I'm not going to go into technicalities because this is a topic for a full-blown PhD, but you could say that aircraft leasing would involve non-transfer of ownership. So it's where you're going and you're getting an aircraft for a certain period of time for a fixed amount of money that you're paying. It's quite simply that. Moving on to aircraft financing is a more solid structure, as they would say, where you would literally, as you would go to finance a car, an airline or another operator would go and to a bank or someone who has the ability to provide finances where you could finance your particular aircraft. So in a nutshell, that's what aircraft leasing and aircraft financing is. Now, before I go into the steamy topic of disputes between parties, I think there are two very, very vital items about aviation and aircraft in particular that I must highlight, which really has a huge effect on how disputes play out, how quickly they're decided, what forum parties choose to go to. The first one is that, and I've got, on social media, I've got criticized a lot for saying this, but I have compared aircraft to a basket of tomatoes, because in my opinion, they are perishable goods where, an aircraft which is not taken care of, the same way if tomatoes are not refrigerated, they will rot and they will be useless. So it's very imperative to keep that in mind, that the asset that we're talking about is not something that can be, parked in a warehouse and kept for an extended period of time. They are literally like living beings where they require constant care and they require constant maintenance. And the reason for this is my second point. The second point is because aviation, aircraft, on every aspect of aviation is absolutely useless. You can throw it in the rubbish bin if you don't have 110% safety. There is no question of 99%. There's no question of 99.9%. You have to have above board 110% safety in all of the activities that you carry out. That is also brings me to another point as to the role of a regulator. Why is this industry so heavily regulated? It is from the point of view of safety. And as Daniel touched upon it, the Magna Carta of all air law is the Chicago Convention. And the Chicago Convention very basically provides the responsibility of providing safety oversight to the country in which an aircraft is registered. So keeping those points in mind, number one, that aircraft are perishable. You can't keep them lying around for a long period of time. And number two, that safety in aviation is key. I will move on to the next part of my discussion or my presentation as to what sort of disputes would you likely see in financing and leasing transactions. Now, as Daniel very rightly pointed out, the first very, very basic dispute you'll ever see is between interparties, which would be between someone who's leasing his aircraft and the other party would be the other person who's taking the aircraft, or alternatively someone who is financing the aircraft for you and the other counterparty would be someone who's taking that financing. Now, the most one would ask, why would there be a dispute between parties? Yes, of course, there are 101 things if people can be angry at each other about. However, the most important one and the most common one that we see is default overpayment. So whether you look at, even in our Indian history, whether you look at bankruptcies that we've had, whether we've seen airlines that have almost gone bust, each one of those instances have faced a very live example of this, where there has been a default, where the operator of the aircraft is not able to pay back the lessor or the financier, and that gives a rise to a dispute between the parties. Now, one would ask, what is the first line of recourse that someone has? So again, a very typical practitioner's point of view is, before you litigate, you first try and get possession of your aircraft, because if this is not a stationary property, it's not immovable property where you can go to court and then try and get possession of it, because of the nature of aircraft, and more importantly, how they fly from one jurisdiction to the other. The aviation has a very unique angle. Today my asset may be in India, but tomorrow it may be in Dubai, and hours from now from Dubai it could be in Istanbul. So along with how an aircraft travels, you're also experiencing various jurisdictions in which it is traveling. You have unpredictability as where your asset is going to be. So your first line of defense is to try and repossess your aircraft. Now, how do you do that? There are a number of ways, which I'm not going to really get into for purposes of this for this conversation, but there are various international law tools. There are various regulations available from country to country whereby you can ground aircraft. Usually the easiest way and the most common way is to try and have the aircraft deregistered. Now, the moment an aircraft is deregistered, it really cannot be flown in any other jurisdiction. It can't be flown in your jurisdiction. So it has to be grounded, because the Chicago Convention, talks about registration only in one country, in one state, etc. So once you have your aircraft on the ground, possibly in your possession, then what do? Then you move on to the next aspect of trying to either recover your money, or you try and recover your any other commitments that the operator would have given you. So be that as it may, the next question you would ask is, what sort of clauses, what sort of provisions do these agreements have? And in my experience, I may be wrong. I don't hold out to be an expert with many decades of experience. But arbitration in most financing and leasing transactions is not the preferred method. And it touches upon another point which Daniel made earlier regarding the Hague CAA, which is trying to change that impression. And it's trying to actually bring parties to the table and say that, look, this is a more effective way for you to do it. However, at least from an Indian perspective and most other perspectives, you will see in all contracts a choice of law clause, and you will see a choice of jurisdiction. And it's a no-brainer that for most transactions, the English law is the chosen one, and the courts of England and Wales are the first preference. You would ask why? The reason for that is number one, speedy justice. Number two, a fair amount of experience in courts in those jurisdictions in such matters. And of course, particularly in India, you look at the concept of reciprocity, whether you can enforce judgments in India directly, etc. So those really are the reasons why such transactions would have English law and the courts of England and Wales as their choice. Arbitration clauses do exist. There's no doubt about that. However, at least from an Indian context, there is always a large fear that once you're complete with the arbitration process, then it could possibly open up a whole different can of worms when you're trying to enforce that, the award that you get, etc. So there is still a bit of a mindset shift that is required. However, as the Hague CAA comes into the mainstream area, people are comfortable with it. Parties are, understanding of what happens. I'm sure that will also, get fairly popular. Now, one would ask, what are the practical weapons between, inter-parties disputes? What we have used in the past is, now you see the thing, this is a peculiar aspect. So in India, let me give you India's example. If you are owed money, or if you have to, try and get possession, the last piece of advice we would give a client is to go to court, for a number of reasons. There's full faith in the judiciary. However, the problem is the judiciary is overburdened. It has too much work, and you can't give an estimate as to how long a decision is going to take, or how long you can get possession or your money back in. So from that perspective, it's going to court and litigating is always the last option. So what would you do in the first instance? The age-old idea is to try and use the threat of insolvency. That previously you would go under the Companies Act, serve companies notices, the lessees notices, etc. But under the IBC, you can also try and pressurize the counterparty to pay up, with the threat of insolvency. However, it does another very, very practical aspect is the counterparty may just not have any money to pay, and in which case you're better off just trying to repossess your asset as quickly as possible. This would also bring me to the next step of mentioning the Cape Town Convention. And the Cape Town Convention, is a very unique piece of international law, which tries to harmonize all the regulations from around the world into one predictable and one unified set of regulations, so that any creditor or financier is well versed and well aware of what he can expect in different countries. I'm not going to go too much into that topic, because it's as I said, it's a topic for a PhD. Any which way, I'm going to move to the next type of disputes that we have after inter-party, which it's a strange statistic, but I recall some research was done as to who the largest litigant is in India. Now, I apologize for the international participants, but my statistics are really only up to date as far as India is concerned. But a very shocking aspect is the largest litigant in India is usually the central or the state government. Now, it could be because someone has taken them to court, or the government is the one initiating the the dispute, but the largest litigant in the country, at least a few years ago, was various state governments and the government. Which brings me to the second types of dispute that we usually see is between a private party and the government. Now, this ties into my initial point as to safety being the paramount consideration in aviation. And safety means that you require a lot of regulation from the regulator who has safety oversight over your operations. That results in a tremendous amount of regulation and requires a lot of interaction with the regulator. So it is very evident that your touch point is going to be with the regulator. So you would likely have a very large dispute, if at all, with the regulator, whether it's grant of permissions, whether it's grant for of deregistration certificates, or whether it's just export clearances, etc. So that would be the second aspect where you may be forced and pushed against the wall to either approach a high court under the writ jurisdiction to either direct the regulator to perform some action or desist from performing some action. So that really is the second part. And if you see the case law as far as financing and leasing goes in India, it is really the Delhi High Court that has laid down a tremendous amount of precedence in this field, where aircraft leasing companies have gone to the High Court seeking, a writ against the Director General of Civil Aviation to deregister aircraft and to permit the export of aircraft from the country. Now, it's really through all of those series of precedents that we have reached a stage which I would call fairly, far down the line, but we really have to raise the bar tremendously, if not more, to reduce the cost of credit for Indian airlines and increase the safety and security of our jurisdiction in the eyes of financiers and lessors. The third type of dispute which you could see is, of course, between the financier and the lessor. So now imagine a transaction where A is leasing an aircraft to, let's say, ABC Airlines in India. Now, aircraft, do bear in mind, are worth millions and millions of dollars. So in all likelihood, A is not going to be the one who has, the funds to carry out all of the purchase and has the funds to really, buy that aircraft. So A, in all likelihood, is also financing that asset from X, Y, and Z. So I'm talking about a dispute between X, Y, and Z and A. So between the financier of the aircraft and the lessor. That's another aspect where you can possibly consider where disputes could arise. The fourth area of dispute is really between the owner or the lessor of an asset. Now let me give you an example. Let's say there's an Irish lessor who has leased an aircraft into India. Let's say the airline who it leased it to has gone, belly up. It's no longer operating, and it has to export its aircraft from the country. As you can imagine, it's a very capital-intensive industry, and usually it's the aircraft lessor or financier who gets stuck, because there is a lot of, there's a perception that the financier or the lessor comes with a lot of money, and of course that the lessor has its asset in country. So there are a lot of liens that are usually exercised, whether it's by persons who perform maintenance on the aircraft, whether it's service providers, ground handlers, etc. That's another aspect which can give rise to a very large amount of disputes between the owner or the lessor and third parties. So I can give you an example of a recent case that we've just been working on, is where our client, who's a lessor, has been trying to export its aircraft out from India. However, there's a creditor in India who is not, in our opinion, of course, there are always two sides to the same coin, who is not eligible to, raise any dues, etc. But in the long run, they have, caused a fair amount of problems in the export process, ultimately leading us to, approach them and, sit across the table and try and resolve that dispute. So this is where my point is that you don't know who you may be litigating with, you don't know who your counterparty may be. And it's a very, very true and a cold reality that you may end up fighting with creditors who have nothing to do with your transaction between yourself and your counterparty. So these are the the vagaries of law. These are the unpredictable aspects of law. And with that, I just would like to part with a few words. As I said, the previous fellow panelist has really covered a lot of the aspects. We really, as a country, as a generation, need to focus on a shift from reliance on courts of law to amicable settlement. Now, why, you would ask me, why is that my opinion? I base that opinion on a number of reasons. The most important being that our courts are completely overburdened. They do not have the time to give each party a very, very, very patient hearing. It is not possible. It's just inhumane, the process. So I would plead with the younger generation, with my colleagues, that we really need to look into these alternate forms of dispute resolution, because ultimately that really is the future. And with that, with those last few words, I would like to throw open the floor to more questions, as I would appreciate answering any questions that anyone has. So dear organizers, I'm done with my presentation. If they're I'm very happy to spend the next few minutes taking questions, or we could just proceed as you wish.
So anybody has any question? I see Dr. Tube, he had raised hand. I don't know when he had done this.
I think it was in the prior session, ma'am.
Okay. So let me check the
Sir,
chat box.
you can check the questions in the chat box and answer accordingly.
So we have a question.
So one of the question is, despite getting an IDERA from the regulator, can the financier or creditor still create problems in the export of aircraft?
So yes. So even though our regulation states that, so just for everyone's information, an IDERA is an irrevocable export and some authorization. It'll come back to me. The idea is, it's a single piece of paper that you go to the regulator with, and the regulator, on receipt of the IDERA, has to deregister that aircraft within a specific amount of time. The Indian regulation says that they have to deregister within 5 working days. However, experience has shown that the regulator has been taking longer in performing that task. And secondly, yes, other creditors who do not fall within the regulation have shown an interest, and the regulator has honored their request, which is at least from the lessor's point of view, it has been a big task to try and overcome that. However, it goes into the same point of, the only outcome is that you have to litigate, and clients would prefer not to go down to the court procedure and just try and negotiate face to face.
Right. There is one more question related to IDERA.
Yes.
Despite India signing IDERA, why is it that taking possession of an asset is still a challenge?
So the IDERA, just for the sake of clarity, is a document that's provided under the Cape Town Convention. Taking possession of an aircraft, despite the Cape Town Convention and the IDERA regulations being in place, is because we have, it goes back to the question of primacy of legislation. The Cape Town Convention currently is only an international piece of law which India has acceded to. However, there are a number of other local Indian laws, the main one being the IBC, which says that on the admission of a petition for insolvency, there should be a blanket moratorium, which specifically prohibits the repossession of leased assets. So that is one thing which is in direct conflict with the Cape Town Convention. So it's practical problems like that, including I wouldn't call it the non-education. No, I wouldn't even call it ignorance, because that's a rude thing, a rude expression to use. But it's a certain ignorance of the law or the regulations by the regulator, or it's a different interpretation. When you're a foreign entity in India trying to take back an asset which, okay, it may rightly belong to you, but you are taking it away from an Indian operator, which people view as, you taking away the livelihood of, an Indian entity, etc. Those considerations really do come into play, where, we have been asked that, okay, this is what's happening. If you can try and help that particular airline, yes, it may be in default, but we would be, highly appreciative of that. So we do get that sentiment very, very often. So those are really the practical reasons why, despite, the huge strides that we've made, despite that, it being fairly difficult to export from India.
Thank you so much for that. Then Hasid asked, we have the concept of maritime liens and in-rem enforcement.
Mm-hmm.
In aviation law, do we have a parallel concept?
So in aviation, yes, even under the Cape Town Convention, we have the standard liens that would be recognized under law, whether it's, either a worker's lien, whether it's a repairer's lien, whether it's, liens imposed by the government for unpaid taxes, etc. So yes, those similar concepts have been incorporated and are recognized. That's why, for someone who's performed any sort of maintenance on your aircraft, you would usually not, try and get into a dispute with them.
Thank you. Then Vinod Agarwal asked, it's up to you to answer about the status of Jet Airways and the IBC.
Yes, I have two words, very sad. That's all I have to say. As I've said also publicly earlier, this is the moment and this is the example for our government and regulators to wake up, and we need specific laws for aviation and insolvency. You can't have this infighting and, the creditors not liking what's happening, and it has a whole, it's shrouded with insecurity, it's shrouded with doubt, it's shrouded with mistrust. So it's very unfortunate.
Right. Then these two questions, I don't know how much of the sense they bring, but whether arbitration help in the field of leasing and financing, or how arbitration panel at Hague help leasing and financing of crafts.
You see, yes, it is obvious. It is definitely something that is a positive step. But you see the practical problem that, and just, for the sake of clarity, I am also an advisor on the Hague CAA panel, and I have complete faith in it. But the challenges we would face in the beginning is, it's not a lessor who's making the decision, as to what law has to apply. It's their financiers, lawyers. It goes back to New York lawyers, to UK lawyers. So people have to get comfortable with that concept. It's really a question of, do you fix something that people don't see broken? It's really that. It is really that. But ultimately, the benefits of the speedy, cheaper, relief that you could possibly get under that process is what will make it shine.
Thank you so much, Nitin, for an exciting talk and answering all the questions patiently.
Thank you for having me. It's my pleasure.
Thank you so much, sir. I thank Mr. Serene for helping us understand the nitty-gritties of the various types of aviation disputes and for truly being so eloquent and comprehensive. Thank you very much, sir. We now move on to the next panelist, Dr. Akhil Prasad. With a 25-year in-house career at reputed global corporates like Xerox, Electrolux, General Motors, Disney, and Fidelity, plus 2 PhDs under his belt, our next speaker, Dr. Akhil Prasad, is Director, Country Council India, and Company Secretary with Boeing India, and is based in New Delhi. Dr. Prasad has been nominated among the top general counsels
in India by Forbes India and is a member of the editorial boards of various journals of international repute. Dr. Prasad is the Vice Chairman and an Advisory Board member of the Corporate Council Committee and a member of the India Working Group of the International Bar Association. He's a visiting faculty with various universities across the country, including NLUD, National Law University Jodhpur, IIT Kharagpur, and even MNLU Mumbai through our association in the form of an MOU with the General Counsels Association of India, which offers a postgraduate diploma on arbitration and mediation at MNLU Mumbai. We are grateful to Dr. Prasad for his constant guidance and support and wholeheartedly welcome him to this conference. And now invite him to grace the occasion.
Thank you very much. Am I audible?
Yes. And welcome.
Oh, thank you. Thank you. So, so I think the first and foremost, thanks to you, Professor Balyan, for including me in this very important seminar, and special thanks to Maharashtra NLU and all my panelists, who have made this discussion so very, very interesting. So my topic is about the role of commercial arbitration in the aviation, on the aviation side. But before I delve directly into the topic, one thing I want to say is that being a part of Boeing is a wonderful experience for me. And the reason for that is because aviation and defense is such a fascinating industry that it thrives on development and innovation, because we manufacture defense products, we manufacture commercial planes, but the main philosophy about the organization is innovation and technology. And it gives me a great pride to be associated with a company which is more than 100 years old, but is still very young in terms of its mindset. And I must confess that, even after 10 years working for Boeing in India, the innovation and the mindset of people and the kind of people we interact with is so great that, they are delivering or making products, which are transporting the world across the globe, which are transporting, we are building satellites, we are building defense products, safety, security. So it's such a fascinating organization. And briefly, I wanted to tell you, that Boeing is synonymous with commercial aviation, but not many know. And in fact, I didn't know when I joined Boeing 10 years ago that Boeing was so big on the defense side. So when we see the commercial planes are sold to the customers who are based in India, the airline companies, and the transactions usually happen with our US company for tax reasons, that a US company, Boeing US, will sell planes to the carriers across the world, and the transactions are usually taking place in Seattle. So the logical contract for a commercial sale would have arbitration provision based in US. The choice of law would be US. And then when we do our international transactions, especially related to the commercial services, the contracts are a little flexible in terms of having an arbitration provision with the LCIA or Singapore. But, as India is expanding, although, our requirements are that it should be a London arbitration or a Singapore arbitration. But, we have impressed upon, our legal teams in the US and made them understand that India has a equally good and a world-class arbitration system. The laws are good. So for Indian services, we are now insisting that we should have arbitration in India under the Indian law. And we are quite confident about the fact that we will be able to withstand or take advantage or in terms of represent our interest before an Indian arbitration forum. On the defense side, the story is a little different, because there is a defense acquisition policy, or a DAP 2020, which mandates defense procurements, which has a standard contract, which is a supply agreement. And whether it's a defense capital procurement or a defense services procurement, whether under a DPM So there is a policy which is known as a Defense Procedure Manual, which usually governs purchase of defense services by the government. And then there is a DAP, which is the Defense Acquisition Procedure, which is for capital procurements. Under these two policies, it is mandated that all suppliers, whether foreign or Indian, they have to comply with Indian law and arbitration in India. This is because required under the government's defense procurement policy and procedures and the services policy. So broadly, we are quite comfortable in terms of, because we believe that some people asked me, when I was a counsel for Boeing, and then people asked me whether how difficult is it to get things resolved. So that was a very important question, that should there be a litigation in India, it takes years to settle or arbitration or commercial disputes. But the experiences have not been so bad. And we have been able to convince our teams that we are good with having an arbitration process in India. So this is on the sales side, the commercial side, the contract side, why and what we prefer in terms of dispute resolution mechanism. I really wanted to emphasize on 4 cases, which have been some, I would say, landmark cases for the aviation industry. 2 of them have been on an international level, and 2 are on India, which I wanted to have a brief discussion today and invite your thoughts and suggestions. The first one is known as the Boeing Airbus dispute. And this particular case, it went up to the WTO, the World Trade Organization. And under this case, because aviation, as Nitin explained, that aviation is a very, it's a long gestation industry, huge investments. The stakes are very high. So for manufacturing a plane, we manufacture a plane, and the parts and components which go inside a plane, they come from about 180 countries. Billions of parts and components, huge. There is a huge interest by the various governments on the aviation manufacturing side. And that is the reason why you see that the 2 dominant players are Boeing, which is from US, and the other one is Airbus, which is from France. And then there are other aircraft manufacturers who manufacture smaller planes, whether it's a Bombardier, whether it's some other manufacturer. Recently, China has developed a COMAC facility where they manufacture smaller planes, a single aisle plane. But the dominant players are Boeing and Airbus. And what had happened was that this particular dispute at the WTO level between the US and the European Union, it started because of the patronage that allegedly US alleged against France, and France alleged against US, that both these countries are subsidizing the planes. And as a result of which, both US and EU were, taking punitive tariff action against the other. And if you look at the value, it affected about $11.5 billion of trade between US and the European Union, where, the EU and the US businesses were required to pay about $3.3 billion. So this is one of the most long-standing disputes, which was between the US and the EU on aviation issue. And it started in the year 2004. And 17 years later, because there was so much financial stake that, there were punitive tariffs which were imposed by the US government against EU and vice versa. There was a arbitration which happened between the EU and the US before the WTO. And this arbitration, tries to solve a problem which has been existing for the civil aircraft. And on 15th of June 2021, both sides, they tried to reconcile the dispute. And then, it was agreed there that there would be a working group for large civil aircrafts, and where each parties' representatives will sit on it. They will magnify, or they will keep under the watch class that these civil aircraft manufacturers, if there is any financing needs to be provided to them, it needs to be on a market terms. The reason for that was, Boeing perhaps alleged against Airbus that the government of France was giving certain concessions in terms of financial assistance to Airbus, as a result of which Airbus was getting a competitive advantage. So it was concluded in that arbitration matter that going forward, it's going to be a financing on a market terms. And then, there were also allegations about providing subsidies on the research and development. And then it was also agreed that both US and EU would agree on an open and transparent process as to government support on the R&D activities for these two large aircraft manufacturers. And it was also agreed that there should not be any action which would harm the research and development of the other party. And it was also agreed that there will be a mutual cooperation so that the industry as a whole does not suffer because of this tariff which was being imposed by EU and US against each other. So in my view, this is one of the most important civil aviation matter which involved the large governments from both sides, a large European Union versus the US government, where there were a lot of efforts to mitigate and resolve the pending issues which started because of the aviation industry. The second case, which is ongoing, and is that about Boeing and Embraer. Boeing, we all know, is a US giant on aircraft manufacturing. Embraer is a Brazilian company which manufactures smaller planes. So it was in 2019 when Boeing entered into an agreement with Embraer to establish a joint venture where Boeing wanted to acquire about 80% of Embraer, and the deal size was about $4.2 billion. And it was essentially to develop the new markets for Embraer's airplane, which is known as C390 Millennium. But just 1 year later, Boeing terminated the contract, terminated the joint venture agreement. And it was alleged that Embraer failed to meet certain conditions of the contract, as a result of which Boeing terminated the joint venture. But Embraer disputed Boeing's right to terminate. And then currently the issue is under the arbitration. So I cannot, being a part of Boeing, because I'm not privy to what is happening in that arbitration, but based upon my research on Wikipedia, it states that why Boeing terminated was because of the valuation, of Embraer because of COVID impact. The valuation of business fell from 4.2 billion to about 1.1 billion, and coronavirus, had its major impact on the transaction. And then the other reason that was mentioned about cancellation of the transaction was that because of this pandemic, it is in the Wikipedia, and I'm not saying whether it's right or wrong, but Boeing took certain government relief from the US government, and Boeing perhaps thought it was not proper, if the government relief was to be used to fund the acquisition of Embraer. And then the third thing was the counter by Embraer was that Embraer said that it was because of the 737 MAX grounding that there was a financial impact on Boeing. So it's ongoing. The arbitration is yet to be concluded, but it is one of the large arbitration matters on the aviation side, where there is no conclusion as yet about what is the outcome, but the size is huge. It's about $4.2 billion on the aviation dispute. So it's a very important case study. The third one is domestic, which is about the difference of opinion or differences between the two promoters of the largest airline in India, which is Indigo. And it was founded, as we know, by Mr. Gangwal and Mr. Bhatia. But as normally happens, when you start with a fanfare, you then continue business for some time, and then there are differences of opinion. So an airline which was started in 2005 went off well till 2015, and there were certain then differences which started to occur between the two promoters. There were allegations, the decision making started to affect at the board level, but then the arbitration was about related to the shareholder agreement, which was signed between the two in 2015. One of the promoters, Mr. Gangwal, wanted to do the EGM, but Mr. Bhatia requested an arbitration before the London Court of International Arbitration. And then, it was affirmed that Mr. Bhatia could have the extraordinary general meeting for amendment of the memorandum and articles of association. And then, there was an exit by one of the promoters of Indigo, and now the issue stands settled. But it did impact the board. It did impact the relationship between the founders, and the matter was resolved through an arbitration proceedings at the LCIA level. The last one which I wanted to discuss today and bring to your attention is about the retrospective tax issue. And this retrospective tax was regarding the case between Kane Energy and Air India. So this issue pertains to the reorg that Kane wanted to do in India. They wanted to sell its assets to Vedanta Group, which was ultimately it was put into effect under. But the government of India, it levied a huge, it imposed a huge tax on Kane because of this transaction, which was challenged by Kane Energy. But what government of India did in 2012 was it amended the tax laws with a retrospective effect, which was again challenged by Kane, before various courts outside, and also in an arbitration matter before the Permanent Court of Arbitration. And ultimately, what happened was that Kane got an award in its favor, which was for about $1.2 billion. And because, and as a consequence of this award, what Kane did, they went ahead and filed various petitions in courts outside of India, and they wanted to seize the assets of Air India, because Air India at that point of time was owned by the government of India. And since the foreign award was in favor of Kane against government of India, so they went ahead to seize the assets of Air India. And at that point of time, I think government of India was very ahead in terms of disinvestment of Air India. And that is the reason why, government immediately decided to settle the issue. And the issue was ultimately amicably settled. And now we know that Air India is a part of the Tata Group. So in summary, I would say that looking at these four important cases, outside India, within India, I think what gives me an impression is definitely that arbitration remains to be a very important source of dispute resolution. And because of the recent changes or recent orders by the Supreme Court of India, where they have now also, taking cognizance of the fact that two Indian parties who are subject to a contract can decide on a foreign jurisdiction and a foreign arbitration is also a welcome step, because it does give flexibility to the parties to decide where they want to have the dispute resolved. My own personal view is that in India also arbitration is good. We have good forums, we have good tribunals. That does not dilute the effect that we should change our concept that the arbitration contract should have an arbitration provision outside of India. I don't subscribe to that view because I do believe we have a lot of good competency within India. But there is a flexibility which is a welcome step, and I do believe that in dispute resolution, flexibility is very, very important. And I'm very glad that our Supreme Court has taken that view to provide the flexibility of dispute resolution, which is available to the litigants. So these are my opening thoughts. I'm happy to take any questions if there are.
So there is a question. How is overall scenario in India and globally for 737 MAX grounding? I think it is claims. How do aircraft manufacturers deal with groundings order by FAA or similar regulators?
No, sorry, I didn't understand the question. It's about the grounding, or the question is...
You can even view into that Q&A, but again I will read.
Okay.
It is how is overall scenario in India and globally for 737 MAX grounding claims. So it is with respect to grounding, and how do aircraft manufacturers deal with grounding order by FAA or similar regulators?
So, whatever orders are, against any manufacturer by a regulator, which is whether a DGCA or whether which is a FAA, I think there is no option but to comply with those orders. And you may litigate or you may, go in for appeal. But the fact of the matter is, there has to be a very fine balance between whether you want to fight a case or whether you want to settle a case. For 77 MAX, I think one of the things perhaps which Boeing did was that Boeing is a company which is pro customer, and I don't think there is any propensity to litigate when there is a very large interest involved, whether of people who lost their lives or people or customers who have suffered. I think Boeing is one of the companies which has always thought in a larger interest of its customers and people who are traveling in those aircrafts. So when it's a regulatory issue, if it was a trade dispute, the first case that we saw, we thought that it's worth fighting because it was a clear-cut case of one manufacturer being benefited through a association of a regulator or the government. So that was an issue which was worth fighting. But then when it was an issue about people who lost their lives, I think it's a very compassionate thing. And every company should have that compassion for its customers and for the people who are flying. And I don't think, I think Boeing did the right thing by providing adequate compensation, which was due and which people were entitled to. And that is what I think was achieved in this particular case.
You are on mute, ma'am.
Thank you, Chirag sir. So another question we have, according to you, why didn't Crane file any execution petition within India and decided to seize assets outside India?
See, I think that would have been a strategy. So whenever you whenever you start a litigation, you try and evaluate a chances of a good win. And perhaps that would have been what they would have been advised by their counsel, that the vulnerability of government perhaps was with Air India, where, it would have been better for Kane to get an award quickly and have the assets attached in a jurisdiction which was outside. Perhaps, I do not know if the same exercise would have been done in India, whether it would have been successful. So I think as a strategy, the legal team of Ken would have decided it to be more effective if they were to do it outside.
Okay, sir. So Mr. Abhinay wants to thank you. It is a great learning experience, which indeed it is.
Thank you so much.
So
Thank you
over
very
to
much
you.
for having me here.
One
It's been a
more
learning
Our
question.
experience
pleasure.
for me.
There's one more question from Vinod Kumar Agarwal
Okay.
about
Yes.
permissions for building more helipads for small aircrafts all over India. Does it fall under public policy or under any other regulator?
I think this is how I see it. I think it is a part of the National Civil Aviation Policy. That government has, government came up in 2016. I think it's a part of the Vision 2020 document also, that government really, the UDAN scheme, where I think government wants to, that every person in this country should be able to fly, whether from whatever economical background. It is I think a step in that direction, that government in this finance act, the finance bill has announced that 15 airports will be developed or revamped, airstrips will be revamped. And this is a very welcome step. I think this is music to ears, that government is investing in infrastructure, which is so badly needed, whether it's roads or whether it's airports or whether it's railways. I think this year budgets had been fantastic in terms of government's determination to really come up with the infrastructure, whether it's for road, railways, and airports. Fantastic.
Yeah, and I like the strategic play it has done on state government, that clubbing it with infrastructure spending and then the money which the center would be granting to them. So they
Of
are
course.
trying to.
Of course.
Yeah, please go ahead.
It cannot happen unless there is a cooperation between the central and the state. And because India is a large country, and unless both the central and the state, they resolve to improve the infrastructure, it will not happen.
Yeah. So volunteer number 3, please.
Yes.
Arjun, please.
I thank Mr. Akhil Prasad for helping us understand various types of aviation disputes and for truly being so eloquent and comprehensive in his task. Thank you very much, sir. We move on to our next panelist, Dr. Luping Zhang. Dr. Zhang is an assistant professor at China University of Political Science and Law and a New York attorney. Previously, she has obtained her LLB from Xinjiang University, her PhD from King's College London, and LLMs from NYU School of Law and Leiden University. She has experience working at the New York corporate law firm and 2 UN organizations. Her research focuses on international air law and international disputes resolution, on which she has published multiple leading journals such as Air and Space Law Journal and Journal for International Dispute Settlement. Over to you, ma'am.
Welcome, Dr. Luping.
Hi, thank you very much for the introduction, and thank you so much, Professor Banyan, for having me here. I'll probably have a PowerPoint shared. I hope it's fine. 1 second. Okay, so today my topic will be very much focused on the book that I published with Oxford University Press last year. And the topic of the whole conference, the resolution of disputes in both aviation and space areas, are very interesting and emerging important questions in international law. I actually echo with many of the conclusions that the previous speakers have drawn, particularly on, for example, Ms. Sarin has concluded his speech on calling younger generations to perhaps pay more attention to the use of arbitration instead of overburdening the courts for dispute resolution in this area. My topic, of course, is very much focused on interstate dispute as introduced by Mr. Allman. But I want to make one point, that is, in the area of both actually aviation and space, how states resolve disputes will inevitably influence how the aviation industry or the space industry, airlines and other, for example, satellite companies resolve their disputes in the future. So my presentation will be, I think, within 30 minutes, and I'll be focusing on the following aspect. One is why should we pay attention to the question? And that the question is the resolution of interstate disputes in civil aviation, how it has played out in history, and how it maybe should be going on certain reforms in the future. And one particular aspect that I'll be focusing on today, as addressed by the previous speaker, is the dispute settlement mechanism within the International Civil Aviation, or short for ICAO. I will analyze a little bit of its mandate, but more on its practice. And I think that is a very interesting topic to today's Indian audience, because I've never presented this topic to any particular audience in one jurisdiction, but I've always said that actually India is a very active participant in using the dispute settlement mechanisms in ICAO, which is not so often to see. But I will elaborate on that point later. And the third aspect is on the latest developments in the area, particularly with regard to the amendments of the ICAO dispute settlement procedure rules. So let's start with the first question: why should we pay attention to this question? First of all, I noticed that some of the audience are still perhaps students, so you may not be so familiar with the idea of aviation dispute resolution. In fact, as well addressed by previous speakers, that the sectorized dispute resolution is becoming increasingly popular, and aviation dispute resolution actually stands out as an example. As addressed by Mr. Ullman, and also I know that Ms. Sarin is also on the board of the recently established Hague Court of Arbitration for Aviation. Aviation dispute resolution has always been a leading example of sectorized dispute resolution. And some of the conclusions that I will draw later in today's speech will also quite interestingly apply to the space dispute resolution, which I note that is a second half, the topic of the second half of the conference. But let's dig a little bit deeper on this particular question: why should we pay attention to the dispute resolution in aviation, particularly against the background after the COVID-19 influence to the aviation industry? My attention is more drawn on the, I would say, compared to the former speakers, more drawn on the theoretical side than the practical side, although it has influences on practice. First is that if we look at the historical trends in international law, we look at how and when international judicial and quasi-judicial institutions were established. There are three stages, as I summarize. The first stage is the proliferation, which means the establishment and proliferation of international courts and tribunals. And many of the courts and tribunals have been mentioned by today's speaker as well. For example, include the establishment of ICSID and how that influences investment disputes in international law. But naturally, from stage one, we move on to stage two, which is called fragmentation. So we see many of the establishment and proliferation of international courts and tribunals. States get a little bit confused as to which courts or which tribunals to go to. So it comes to stage three, where you see certain states actually begin withdrawing from certain international judicial organs. And that is the part is a little bit uncertain. So some states have practiced in that particular orientation, but other states may or may not follow. So the question is, how do we actually orient the dispute resolution in aviation? the ICAO Council is, of course, a leading example in the whole dispute resolution mechanisms or dispute resolution institutions in aviation, in international civil aviation. And for a while, it was suspected to be withering with its dispute resolution function because it has been criticized or challenged to play only a diplomatic role. But we see a very interesting trend since the year 2016 with 2 additional cases brought to the ICAO Council. So one of the conclusions of the book that this particular presentation is based on is actually individual cases revitalized mechanism. And that gives you an idea of why should we pay attention to this question, because even though theoretically the institution, the ICAO Council as an institution, was suspected to be withering, we see individual cases actually brought to the Council, and Council was or still is to be expected to play certain roles with regard to dispute resolution functions. So on the left, this is the book that I've written, which was based on my doctoral study in London. And the whole main research focus of the book is really to investigate the dispute resolution mandate of the ICAO Council of the last 70 years. So that was the time since the conclusion of the Magna Carta, the Chicago Convention. And the book seeks to answer the following 3 questions. I'll be very much focused on the first and perhaps a little bit on the third question, given the time limits. The first question is, should the ICAO Council modernize its structure to fulfill its dispute resolution function? And second, as mentioned, that certain, a large bulk of air service agreements or so-called air transport agreements have been left out by Chicago Convention. So those air service agreements actually are concluded mostly on a bilateral basis. Should the dispute resolution mechanisms be adapted to the changes? And third, if certain changes need to be made in this particular area, what form should reforms take? So first, let's look at the ICAO dispute settlement mechanism. For the audience that have spoken before, and for many, I think at least 50% of the audience here, you perhaps have known the Chicago Convention very well. But just to give you a recap, in Chapter 18 of the Chicago Convention, particularly in Article 84, it has a 3-tier mechanism or a 2-tier legal mechanism, with the first tier as the failure of negotiation between 2 states to Chicago Convention. And then if the states aren't satisfied with the negotiation results, they can bring the dispute under Article 84 to the ICAO Council. And ICAO Council will be obliged to render a decision. And if they're not happy with that decision, the state can choose to bring either the appeal to the International Court of Justice or to an ad hoc arbitration tribunal. And that is the system designed by the drafters of the Chicago Convention. This particular settlement of dispute mechanism seems to be quite general. In fact, it has a lot of loopholes. For example, there's an inherent conflict on a normative level, which we refer back to Article 54 of the Chicago Convention. For example, Article 54 is not about dispute resolution of the ICAO Council. It is actually about the general function of the ICAO Council because it has many roles. And it has a miscellaneous provision which stipulates the following: that the Council is mandated to consider any matter relating to the convention which any state, contracting state, refers to it. If we move back to Article 84, we see here, in fact, in a formal legal dispute that a state brings to the ICAO Council, the content should be either the interpretation or application of the Chicago Convention and its annexes. While when reading Article 54 of the Chicago Convention, it actually says the Council is obligated to consider any matter. And of course, many would say this particular provision is not really about dispute resolution. It only says the Council is obliged to consider. So it could be a political/diplomatic role. But in either way, it has buried certain loopholes in the Chicago Convention per se, which later we see states get really confused in the dispute resolution procedures. So what is ICAO Council and what is ICAO Council's role with regard to dispute resolution? In summary, the Council, of course, is a permanent body to ICAO. It is composed of 36 member states, and it is elected by the Assembly for every 3-year term. In fact, we will see later in the PowerPoint that the latest term is the year 2022 to 2025. So we have new members in the Council. And the Council's role, this particular paragraph is copy and paste from the ICAO official website. It says, on occasion, the Council may act as an arbiter between member states on matters concerning aviation and the implementation of the provisions of the Convention. Also, it may investigate any situation which presents avoidable obstacles to the development of international air navigation, and etc. So the first thing that we notice here is that when reading from the angle of ICAO, it says this dispute resolution function is something that the ICAO Council is expected to conduct on an occasional basis. And when the Council acts as a dispute settler, the Council is not expected, or at least not working as a court, but really an arbiter between member states. So that gives you a sense of how ICAO Council from the very beginning is quite unique in terms of dispute resolution. If we think about a comparable example, we look at for example, the dispute settlement body, as mentioned by Dr. Prasad regarding the Boeing and Airbus subsidy cases, etc. The dispute settlement body in the WTO is distinctively different from, for example, the Council in the ICAO. So we see when ICAO Council is oriented at this level, any state cannot expect it to work fully functioning as an independent court. So there has been debate historically as to the nature of the ICAO Council and its representation, as well as one of the major loopholes or the major criticism, which is on the due process. The nature, of course, today after the case of the Middle East case between Qatar and other countries, it is defined generally speaking as quasi-judicial, and the Council is represented by 36 member states. And if we want to dig deeper on its due process, let's take a look at its cases later. So the Council's nature, for example, there has been debate on whether or not it's historical, political, legal, or even technical. Because if you read the book, it has done an empirical research of the members that actually have decided on those cases, and many of the representatives, they have a lot of experience or more experiences in, for example, air navigation instead of judging on a particular legal case. But the Council's representation is actually very similar, or upholding the principles in general UN organizations. it has three tiers. The first tiers is given to the states of chief importance. The second is to encourage providing the contribution to the provision of facilities in international civil air navigation. And the third criteria, the tier 3, is to ensure the geographic representation in the council. And the latest one, the council states, we see part 1 with, for example, United States, China as well, but a major country is missing here, which is Russia, because of the many tensions it has received last year. So Russia didn't win the election to the part 1 stage in ICAO Council. We also see part 2 and part 3 countries where the it shows certain countries are actually re-elected, for example, India. So all of those countries, or those 36 states, they each have 1 vote, and they're equal when deciding on an ICAO case. So let's look at actually how many cases have been decided by the ICAO Council, brought to the ICAO Council dispute resolution function. Here, I give you a few seconds to read. We see here, India is, as I've said before, is a quite active participant. In fact, India makes a great contribution to the dispute resolution function or history of ICAO Council, because the first ever case brought to the Council was between India and Pakistan in the year 1952. And that case was very important to the Council because before the decision of this particular case, the Council didn't even have a rules of procedure. So India versus Pakistan in 1952 actually pushed the Council to write down its first ever rules of procedures. And at the time, the blueprint was based on the International Court of Justice rules of procedures. And again, later in 1971, there was another case between Pakistan and India. And that case was also a milestone for ICAO Council because that was the first ever case appealed to International Court of Justice. Until this day, only 2 cases have gone through an appellate procedure. So the first one was Pakistan versus India, and the second one was more recent between Qatar and Bahrain, Egypt, Saudi Arabia, and UAE. But ACJ later will see a little bit more detailed analysis of its role played on a bit of deciding the nature or given the interpretation of the orientation of the ICAO Council. And the second, the question that I want to show you is actually what those states are fighting or have been fighting about. Most likely commercial aircraft's rights, close of airspace, again, commercial aircraft's rights. But there are some unique cases. For example, at the beginning of the conclusion of the Chicago Convention, not so many people pay attention to the issue of environment. So environmental lawmaking till today, for example, we very often hear about the COSIA lawmaking. It is a relatively new issue. So it was not until the year 2000, there was the first ever case brought to the Council regarding the noise emission regulations. And there's also a quite unique case between Brazil and the United States regarding air operators' responsibility, which is more about aviation safety. But this case was, I would say, is really an outlier of the more general cases, type of cases received by the ICAO Council. But following that, I want to use this particularly and latest case to show some of the arguments that are made in the presentation. So this case actually has gone through perhaps a very lengthy procedure because it was actually first brought to the attention of the diplomatic channel, then escalated to the ICAO Council. Then the parties weren't happy about ICAO Council decision, brought to the ICJ. The ICJ kicked back to the case to the ICAO Council, and finally it reached her settlements under the influence of the ICAO Council. So for anyone who is interested in studying on the ICAO Council dispute settlement procedure, this would be a very interesting case to look at. But one of the major criticisms from the applicants in this case and why they wanted to bring this case to the International Court of Justice is because they attacked ICAO Council of its failure to act judicially and also of its lack of due process and certain reasons on the incompetency of the case of the ICAO Council in deciding in this case. So what this case was about, it was against the background of a diplomatic tension between those countries back in the year 2017. So this case was quite intertwined with the backgrounds of certain other obligations in international law. For example, the accusations at the time was that Qatar breached the Riyadh agreements and other counterterrorism obligations under international law. So this whole idea of the Middle East air blockade gives on a very normative level, gives the idea of if the case is not only limited to the Chicago Convention, but relating to general international law, for example, counterterrorism law, is the ICAO Council or is not ICAO Council competent to decide on this particular case? The ICAO Council per se was very sensitive dealing with these issues and actually responded that the overarching political issues to be addressed in a so-called appropriate fora. But when the case was appealed to the ICJ reached on two grounds. One is that the ICAO Council actually had jurisdiction of this case because the core of the issue was actually relating to the Chicago Convention. And secondly, more importantly, it was clarified before in a case that I've said between Pakistan and India in the 1970s. But the ICJ actually became more apparent in its attitude, saying that ICAO Council was not expected to act as a judicial organ, given the political composition of the organ. So that was pretty much the most authoritative or official idea from the ICJ on this particular issue. So finally, let's take a look at the recent development since the Qatar case. So since the 37th session of the Legal Committee of ICAO, which was held in the year 2018, it's the item of reviewing the ICAO settlement rules, which was the rule on the rules of procedure for how ICAO Council decide a case. It was included in the working program, and it has obtained a quite high priority. As approved by the Council, the ICAO actually has held several working group meetings to decide which parts of the rules of procedure should be updated. And from the feedback, at least from the Chinese delegation's feedback, much of the discussion is focused on the following 6 issues. The first is the nature of the ICAO Council. And the second, as exampled by the Qatar case, was when the states bring the dispute to ICAO Council, they have to show the evidence of there's a failure of negotiation. But what really is that standard failure of negotiation is quite unclear. So the states really want to clarifications on this particular standard. And the third development is on more clarification on legal reasoning. And for that, I want to say that many of the, or almost all the cases decided by the council decide the case without elaborated legal reasoning. And that is one of the reasons why the council was constantly criticized, at least for its dispute resolution function. And also there are certain related issues, for example, the statute of limitation, the issue of confidentiality, which is more common to achieve, for example, in arbitration. And also the sixth issue, which is lack of interim relief, which is very important for aviation industry, both for airlines and for states. So that sort of issues, at least these six issues are, we perhaps can have some expectations on the updates in the amendments. So the conclusion of the book in general is that the resolution of dispute in international civil aviation can compare to what I call a swinging pendulum, where the parties and the dispute settlers oscillate between the idea of era politics, which is how politics influence aviation, and a fully judicialized system. One cannot say that the reforms is going to be going on one direction of a fully judicialized system. But as more detailed feedback or conclusions from the book is that we see the lack of judicial capacity remains to be a very strong restraint for resolving international civil aviation dispute under multilateral air law treaties and mainly Geneva Convention. And in connection with the second point, which I've a bit ignored given the time limits of this presentation, is that the dispute resolution mechanisms on the bilateral air service agreement would also benefit from reforms such as an institutionalized arbitral mechanism, because currently all the dispute resolution almost always refer to ad hoc arbitration tribunals. And of all options for reforms, establishing an arbitral institution could be an optimal choice for dispute resolution under both multilateral air law treaties as well as bilateral air law treaties or agreements. And that is a very good way to accommodate both public and private interest. For that, I conclude my today's presentation. I, of course, have received many reviews and comments, and I also welcome further reviews and comments in the future. And that is the end of my presentation. Thank you very much.
It's a very interesting work, Dr. Liu Ping. I haven't read your book, but I'll definitely, after listening to your presentation, try to get my hands on it. Thank you so much.
Thank you.
Do we have any questions? Participants, if you have any questions, you can put in the Q&A box. There are two questions, but not very much directly related to your presentation.
Okay,
One
no
is
problem.
aviation laws are quite unique and specific to the industry. Would it be beneficial to have a specific aviation arbitration forum? I don't know what aviation arbitration forum Manubha Singh means, but if you have some thoughts on this.
Yeah, I would just simply give a brief answer. I think I think he refers to, for example, the Code of Arbitration established before in Shanghai, as mentioned earlier, and also the recent development in Hague. I think it would be very beneficial to read on the news on that part.
Right. And then there are also some associations like space arbitration associations, which are informal groups and promoting space arbitration or aviation arbitration.
Right. Yes, I think also there's a recent development in Dubai regarding the space industry. And for sure, I think there will be more space, perhaps space arbitration court in the future.
Right. Again, Kempemba, Luquisa, it's pertaining to India's position in the world aviation market. And then he said, what is the other way of settling dispute despite India being operating in this industry? The question is not clear enough by Kampamba. If you can clarify this, Kampamba, probably we can try to address this. So, Liuping, if I may ask you, what motivated you to write this book? Was it an extension of your PhD thesis?
Oh, yes, it is actually very much based on my PhD thesis, but also the motivation is actually coming from practice, because when I started become interested in this topic, there was not even the case of Brazil versus US, not to mention the Qatar case. But I felt that the aviation industry or the whole aviation sector actually requires a lot of attention with regard to sectorized dispute resolution. And I feel very delighted. Actually, the practice has met my hypothesis. And I also just want to mention another point is currently I'm trying to apply certain approach in my research to the space dispute as well.
Right.
And that I think will be a very interesting development.
Right. So there are not many, in fact, academicians, as you know, in the aviation and space industry. You can count them on fingers. And you are one of the emerging one, especially your book, which was published by the Oxford. What would be your guidance to the academics who would want to develop their expertise in the aviation or space law?
Yeah, I think I will give the, I wouldn't say advice, but part of my personal experience is that when I joined Academy and specialized in this particular area, some people tried to stop me and saying it's such a small field. And one of the things that I've done is to start looking at issues that is both interesting to the audience in air and space law, but also to general international law. So, for example, in this book, when I frame the resolution of dispute, the resolution of disputes in international civil aviation, I try to attract two streams of audience. One is those conducting research in air law, but also those people who are actually join the practice in international arbitration and related fields. So I think that would be a very good hint for students or particularly younger scholars to join this field.
Right. Thank you so much, Dr. Liuping, for joining us. It was such a pleasure to host you, and we hope to stay connected.
Thank you.
I thank Dr. Zhang for such an elucidated explanation of the interstate disputes in civil aviation and helping us understand such arduous topic. And thank you very much, ma'am. Next on the panel, I'd like to introduce Mr. Brendan Piera. Mr. Brendan is a part of the international disputes team at Arna Law LLB and is experienced in niche areas of practice, which include aviation, wherein he was also part of the general counsel at Qatar Airways in Doha. And he's also includes in his practice the shipping litigation, apart from the contentions and non-contentious areas of law. His aviation expertise includes drafting, vetting, negotiating, and general strategic advisory on agreements, including but not limited to sale, purchase of aircrafts, dry and wet lease agreements for several airport terminals across the airline network, business service agreements, and also sponsorship agreements. Thank you, sir. If you may proceed.
Hi, Brendan. Welcome.
Hi, thank you all. I think I would really like to start my presentation and address by really thanking the MNLU, formidably led by Mr. Balyan. I really thank you for this opportunity. And being a Bombay boy, I'm really proud of this institution, because at least when I concluded my law, the only famous institutions were Government Law College and PGCL. So I think it's a fantastic institution, and all students are and faculty are very fortunate and lucky to have this institution finally in Maharashtra and in Bombay. To begin my address, I think secondly, I would also like to thank all the speakers who have fantastically covered most of the topics and have left me with a smaller area to cover. And it is, I think, thankfully, lessen the burden on me. But I would really like to touch on an important topic of mediation in aviation disputes. I think, like this field, it is also a niche practice area, which is not, I would say, not bloomed as much as the other practice or alternate dispute mechanisms, but is really upcoming, especially with the Singapore International Mediation Convention, wherein certain guidelines have been set across. So to come straight to the point, I'll try to keep it quite brief and deconstructed, considering the audience here are mostly academics and students. So I will try and simplify all the process, considering, again, this is a very niche area of practice and a complicated area of practice. So to start my presentation, I would like to first address as to what are the common areas of disputes, like our other esteemed panelists have already illustrated. The main areas of practice of disputes generally involve litigation or arbitration. That is, either you invoke the jurisdiction of the court, or there's a dispute resolution clause in your contracts, which commonly, try and address the disputes to arbitration and decide them. So why would somebody at this stage then want to mediate it? Especially when mediation is not, first of all, it's not binding. It's not binding on the parties. It is confidential in nature, and you cannot enforce it. So what are really the advantages? Because generally speaking, aviation disputes are traditionally been resolved through litigation and arbitration. And the advantages of litigation and arbitration is that you can enforce those judgments or awards which are in your favor. So through the traditional practices, assuming I have a claim against a debtor, and I institute, from a practitioner's point of view, I would initiate an action or legal claim against the judgment debtor through arbitration or through the formal court proceedings. The final stage is I get an award against him. Now, what will I do of such an award? Why is it so important that, does it really come to an end? Does it attain finality when I get a judgment in my favor? Is that like a thing to rejoice upon? I would, in my humble submission, say no, because in India, for all practical purposes, that the buck doesn't stop there and it doesn't end there. In fact, it just starts there, because as far as domestic awards are concerned, once you get a final judgment, the next stage would be to locate the assets of the judgment debtor, which again is a very tedious and painstaking process. I know some of my colleagues who have addressed the part of arbitration and all are, we're trying to move forward, and India is a developing nation, and, trying to fasten the process, but it still takes some time. On average, I would say almost a year and a half, and which sometimes can be frustrating for a creditor, considering the huge amounts involved in this field. So once these are the practical hurdles what one would face, and therefore would be very difficult to locate the assets. Thereafter, apart from locating the assets, there are disclosure of assets, which again will fall on the burdens of the court. And we already do see courts taking time to decide upon issues like this.
Secondly, as far as foreign arbitral awards are concerned, they also have to pass the test of recognition. Basically, so for example, if most of the clauses or arbitration clauses have either governed by Singapore law or English jurisdiction. So once you get a foreign award and then I come and enforce it from an Indian point of view in India, within the Indian jurisdiction, first I have to pass the test of recognizing an award. This again is a very time consuming, as the award debtor is likely to raise contentions, and they are always looking to defeat the claims of the creditor, meaning the second party would always try and challenge this award basis on XYZ reasons. For example, on public policy, or saying that the arbitral award was passed in duress, and you never know. So basically, why advocating the need for mediation is that once a dispute resolution is invoked or litigation is invoked, especially in aviation disputes, you tend to lose control of the site. You tend to lose control of your commercial acquisition of what you want to attain in the first place. Secondly, you're also dealing with difficult procedures in Indian law, which as far as related to execution and attachment, because these proceedings at a ground level in theory seem to be very easy and but when you tend to execute it, it can be time consuming and it defeats the purpose altogether. Moving on with my presentation, the second part of it is the litigation and arbitration proceedings always, or generally in most cases, take longer than a mediation. This, in some cases, it reduces the efficacy of the award, because not only from the time of initiating my arbitration proceedings, my asset against which I'm looking to enforce it, that can deteriorate in the first place. For example, in my personal experience, there was a proceeding before the Bombay High Court, wherein we obtained a foreign award. We also managed to file executing proceedings in the Bombay High Court. That was vigorously challenged by the other side. But no sooner I started execution proceedings, finally we came to the conclusion that the asset against which we were executing it considerably depreciated in value, because it was in an idle state. Though we had got an attachment, that is the other side of not alienating the properties before the arbitral tribunal or the arbitral proceedings came to an end. But it was infructuous, because it was equivalent to a paper award, because by the time I went to execute it against the asset, it was much lesser than the value of my claim in the first place. So it's like, an example of spending bad money over good money. So why, coming back to my fundamental question, is why mediation, especially in an industry like this? And I would address it on the points that the aviation industry is particularly suited to resolve disputes via mediation, because inherently, due to various benefits of mediation process, is to make favorable from dispute resolution. Mediation can either be informal or formal. By meaning of informal, I would say is that you have a dispute resolution clause, which is generally within the organization or referred to experts within the organization, or jointly appointed by the parties. And the second aspect of formal mediation is through obviously an institutional set of institutes like the SIMC or the SIAC, who you would incorporate it in your contract, wherein you would say that the mediation would be governed by SIMC rules, and then you have a list of expert panelists to go. Again, the advantages, you have a definite list of experts to choose your mediators from. Secondly, why I would say it is, mediation would succeed in this field is because of the niche practice areas. You are generally dealing with limited number of suppliers. For example, again, the manufacturers, if I can pick on my fingers, it's only Boeing and Airbus. And if I were to deal with large entities like them, I would want a stable business relationship throughout the course of my business. So why would I want to dispute, or even assuming I have a small amount of claims against them, I wouldn't want it to blow into a full-blown dispute or take it into arbitration or invoke the jurisdictions of the court. Rather, I would try and, amicably resolve them through mediation, either formally or through appointing somebody known to both parties and resolve the matter. This not only saves time, but also is very cost efficient, especially to the various stakeholders involved. Secondly, it also helps in speedy disposal because non-disputants always like to, they don't want to avoid significant cost and spend time in resolving a dispute. Litigation and arbitration proceedings generally take longer to conclude than mediation. The Singapore International Arbitration Center reported that during the period of 2013 to 2016, the mean duration of arbitration cases was approximately 13.8 months, whereas the median duration was 11.7 months. Prolonged legal proceedings are disruptive to parties' business and can result in significant costs. On the other hand, most disputes in mediation are resolved within two or fewer full days session. Mediation proceedings are facilitated by a neutral and independent mediator who guides disputants to find mutually beneficial solutions. So basically, again, like we are already aware that arbitrations and litigations can go on for eternity. But as far as mediation is concerned, you can set a definite amount of time with a mediator, and you can draw out all your issues on that specific day, and eventually come and sort out at a commercial decision in the end. Secondly, it also is a big player. Considering the amount of disputes at hand, it's confidential in nature. So you are rest assured that the information or the trade disputes or the secrets are confidential, and it will remain between the parties or within the institute or within the mediators adjudicating these disputes. It will not become of public knowledge, at least very easily. The most recent case which comes to my mind is the Qatar Airways dispute with Airbus. Though initially, again, it was very confidential, but then suddenly it blew up into a big dispute wherein the courts of London were invoked, their jurisdictions were invoked, claims amounting to almost 2 billion USD with respect to the paint issue resulted into grounding also of the aircrafts. But finally, what happened? It was an out-of-court settlement, and just I think 2 days ago, there was a public statement issued saying that the disputes were confidential in nature and the settlement was confidential in nature, wherein both parties agreed to settle their disputes and continue that ongoing relationship. So thus mediation once again, comes out as a winner. Not to forget that obviously you need dispute resolution tools like arbitration and the court's jurisdiction, because not all matters can be mediated, specifically if you want to repossess your asset or you're looking to get urgent interim reliefs. Definitely mediators or individual assessors do not have that jurisdiction, do not have that power to get your asset within control. But of course, there are pros and cons to each and every dispute resolution clause, and it can only, to conclude, I would say, is going forward, it would be beneficial to add a mediation clause in your dispute resolution as a prerequisite, considering many many institutions. Apart from institutions, even the Commercial Courts Act in India now specifies mediation as a prerequisite to going to any dispute. So why not incorporate it in all contracts throughout, considering some disputes do not need to be litigated and can be resolved at a more lower level and a professional level with parties who have the relevant expertise. So yeah, I'd like to conclude with that, and I'm open to any practical questions to be discussed with the students. Thank you.
So thank you, Brendan. We have one question. It is, are there enough apart neutrals mediator? Okay, so are there enough neutral mediators who will not carry any influence or bias, knowing that the aviation industry is closely connected? Can you share examples in public domain where mediation award turn out to be very benefiting?
See, as far as expert mediators are concerned, depending on the institution you choose, of course, there would be absolutely non-biased mediators. It is up to both the parties to have that expertise to know what they're selecting and what is the nature and quantum of the dispute. Pursuant to that, I think a conscious decision has to be made by the parties to whom they are selecting. I think that would be the best approach.
Okay. Any other question? Anybody?
So
No.
Brendan, if I may, what do you think about mediatability of aviation disputes? Can all kind of disputes be mediated, or do we put a bar somewhere?
Chirag, I think your question is absolutely right. I don't think all disputes can be mediated. All aviation disputes can be mediated. Like I discussed, considering, there can be some matters wherein there is a repossession or possession of an aircraft, wherein immediate interim measures need to be sought, and mediators do not have that power to do so. So I believe, to start with, I think the quantum is very important. You can either decide on the quantum or the nature of the claims. I do believe that claims with respect to, say, for example, many consumer complaints with respect to the aviation industry, like for example, lost and found baggage, or certain problems arising due to air travel, those definitely can be mediated 100%, because the quantum on an average, I don't think would be as large as what you would say with respect to, say, a sale and purchase of a aircraft, or a wet lease or dry lease. So those definitely, I think, can be. But I think, yes, it would be helpful. Like I think our first speaker mentioned, that on similar aspects of LMAA provisions, like how shipping trades have an individual arbitration center, I think it would be useful to have one as far as aviation is concerned. And I think the Hague Court of the aviation would really help pave that bar.
Thank you so much, Brendan, for an exciting session.